Welcome to the Pencil Bob channel. I hope you enjoy my stories.
Another easy win. I've done this before. That's the first thought I had when I saw the envelope sitting on my desk, the Creekside Commons HOA logo printed in the upper left corner like a little embossed declaration of self-importance. I didn't need to open it to know what it was. I've developed a sense for these things over the years, a kind of low-grade dread that activates whenever I see that particular combination of fonts, the way a veteran develops a twitch for sounds that remind him of things he'd rather forget. I poured myself a bourbon, sat down in the chair by the window, and opened it with the letter opener my father gave me, the one I keep on the desk more out of habit than necessity. Notice of violation. Property at they listed my address. Unauthorized temporary refuse container visible from common area. You are in violation of Section 6(2)(a) of the Creekside Commons Community Standards and Architectural Guidelines. You have 14 days to remedy this violation, or fines will be assessed at $75 per day until the violation is brought into compliance. I set the letter down on the desk and looked out the window at the dumpster. It sat at the edge of the backfield exactly where I'd placed it, exactly where my crews had been working for the better part of 2 weeks clearing decades of accumulated brush from the tree line. It was on my property. Every square inch of it. Not adjacent to the property line in some ambiguous way that might invite debate, not close enough to the boundary to create any reasonable confusion, but squarely, unambiguously, on land that I own outright and have owned for longer than Creekside Commons HOA has existed as a legal entity. That's the part that has to be understood before any of the rest of this makes sense. I own land that sits next to Creekside Commons, but I am not part of Creekside Commons. I am not subject to their covenants, their architectural guidelines, their community standards, or any other document their board has ever produced. That fact was not merely asserted or assumed, it was litigated. In a courtroom, with attorneys on both sides and a judge presiding. 25 years ago, when the HOA was first being formed, their original board made a run at absorbing my property into their jurisdiction. They had a theory about the boundary lines, and they pursued it with what I'll charitably describe as enthusiasm. The judge was not persuaded. The boundary was established, the judgment was entered into the record, and for a period of time that I can only describe as blissfully quiet, everyone seemed to understand where things stood. The problem with homeowners associations, the structural, fundamental, inescapable problem, is that they have no institutional memory. They have files, technically. They have records and minutes and correspondence going back to their founding. But what they do not have, what they seem constitutionally incapable of maintaining, is anyone who actually reads those files before deciding to act. Every 7 to 10 years, a new board gets elected, invariably composed of people who have confused the management of a neighborhood association with the exercise of genuine authority, and they go digging through the old records looking for unfinished business, and they find the complaints without reading the outcomes, and they think they've discovered something. They see that a notice was once issued against my property, and the thought that follows, as naturally as water running downhill, is, why aren't we still doing this? And so here we were. Again, the dumpster sitting in my field, the letter sitting on my desk, and me sitting in my chair with a bourbon that was getting warm while I thought about how to handle the opening move of a game I had already played and already won. I picked up the phone and called Gary. Gary has been my attorney for going on 15 years, which means he has been my attorney through the last 2 iterations of this exact situation, and when he answered the phone and heard my voice, there was a particular quality to his greeting, not quite resignation, not quite amusement, somewhere in that complicated territory between the two, that told me he already had a sense of what was coming. They sent you something, he said, before I'd gotten through my first sentence. A violation notice, I told him. They're calling the dumpster an unauthorized temporary refuse container visible from a common area. They're citing Section 6(2)(a) of their community standards. They're giving me 14 days to remedy the situation, and they're threatening $75 a day in fines if I don't comply. And the dumpster is on your property, Gary said, in the tone of a man confirming something he already knew to be true but needed to say out loud for the record. "The dumpster is entirely on my property, Gary. We're clearing the back field, we've had crews out there for 2 weeks, and the dumpster hasn't moved an inch from where we set it down on the first day. There is no ambiguity about this whatsoever." "Right," he said, and I could hear him already pulling up something on his computer, already thinking 3 steps ahead the way good lawyers do when they've handled a situation enough times to know exactly how it unfolds. "Here's what we're going to do. You're going to scan that notice and send it to me today, and I'm going to draft a response that lays out the full history, the 1999 litigation, the boundary determination, the recorded judgment, all of it, and we're going to send it to them certified mail, return receipt requested, so that there is absolutely no question about whether they received it and when. The letter will include a formal cease and desist demand covering any further notices and any attempt to assess or collect fines related to activity on your property, and it will make clear that any further action on their part will be treated as harassment and will result in legal action on yours." "You think that's going to stop them?" I asked, because I genuinely wanted to know what he thought, even though some part of me already suspected the answer. Gary was quiet for a moment in the way he gets quiet when he's choosing his words carefully, not because he's uncertain, but because he's precise. "Honestly, no," he said. "In my experience, the kind of board that sends a notice like this without doing 30 seconds of research to find out whether the property in question is even in their jurisdiction is not the kind of board that reads a cease and desist letter and says, 'Well, we've been informed we're wrong, let's stop.' What they're much more likely to do is hand it to whatever lawyer they have on retainer, and that lawyer is going to tell them they have a problem, and then you're going to find out pretty quickly whether the board listens to their lawyer or not. Some do. Some absolutely do not. But we have to send the letter regardless because we need to establish the record. Every response we make, every document we generate, every certified letter they sign for and then ignore, that's all going into the file that we're eventually going to put in front of a judge. And I want that file to be immaculate." I told him I'd scan the notice and send it within the hour, and I did. Gary had the response drafted within 2 days, 4 pages on firm letterhead, methodical and precise, laying out the history of my property's relationship to Creekside Commons with the kind of calm, documented clarity that only becomes possible when the facts are entirely on your side. It referenced the 1999 case by name and docket number. It attached a copy of the recorded boundary determination. It quoted the relevant sections of the original judgment. And then, in language that was professional and restrained, but left absolutely no room for misinterpretation, it told them to stop. We sent it certified mail on a Thursday. They signed for it the following Tuesday. I know the exact date because I have the return receipt sitting in the folder on my desk, right next to the original violation notice, right next to the letter that arrived 4 days after the return receipt came back. Not a response, not an acknowledgement, not even the courtesy of a form letter saying they'd received our correspondence and were taking it under advisement. Just a second violation notice, same case number as the first, same section citation, same boilerplate language about community standards, except now there was an additional paragraph at the bottom that had not appeared in the first notice. Please be advised that fines have been assessed on this matter as follows. Initial fine assessed date, $75. Daily accrual since date of initial assessment, $525. Total outstanding as of date of this notice, $600. Payment is due within 30 days. Failure to remit payment may result in additional legal action, including the filing of a lien against your property. I read that paragraph 4 times. $600. They had received our letter, they had received the certified mail return receipt confirming they'd received our letter. They had in their possession 4 pages of documented legal history explaining in precise detail why they had no authority over my property, and their response was to send me a bill for $600 and threaten to put a lien on my house. I scanned the notice, emailed it to Gary, and typed a message underneath it that I'm not going to reproduce here because it contained language I generally try to keep out of written correspondence, but which I think most reasonable people would consider justified under the circumstances. Gary called me the next morning. "I saw your email," he said, and there was something in his voice that I recognized after 15 years as the sound of a lawyer who is professionally obligated to remain calm but is privately enjoying himself. They ignored the cease and desist, Gary. They didn't just ignore it, they sent me a bill. They sent me a bill for $600 for fines assessed against property they have no legal right to regulate, after receiving a 4-page letter from my attorney explaining exactly why they have no legal right to regulate it, and now they're threatening a lien. I know, he said. I read the notice. And here's what I want you to understand about what's happening right now, because I think it's important. What they've just done is significantly better for us than if they'd simply backed down after the first letter. Because now we have documented evidence that they received formal legal notice of their jurisdictional overreach, and they chose to continue anyway. They chose to escalate. They assessed additional fines after being told in writing that they had no authority to assess any fines at all. And now they're threatening a lien. Every single one of those decisions is going into the record, and every single one of them is going to cost them when this gets in front of a judge, because a judge is going to look at that sequence of events, and they are not going to be sympathetic to a homeowners association that was told to stop and kept going. So we wait, I said. We document, Gary said. We keep every piece of paper they send us, we note every date, we track every dollar they claim to be assessing, and we wait for them to make their next move. Because they will make a next move. People like this always do. He was right. The dumpster came out of the field on a Wednesday, right on schedule when the brush clearing was finished. Not one day earlier than planned and not one day later, because the schedule was determined by the work and not by anything Creekside Commons had to say about it. By Friday of that same week, I had a new letter on my desk informing me that while Creekside Commons noted the removal of the unauthorized refuse container, fines had continued to accrue through the date of removal and the total outstanding balance on my account. They actually used the phrase "my account," as though I were a member, as though I had ever been a member, was $1,575, due within 30 days. And then, as if that weren't enough, tucked behind the fine notice like an afterthought, was a second letter. A new violation. The fence. We had replaced the fence along the boundary of the backfield as part of the same project, new posts, new boards, same location as the old fence, within inches of the original line, a straightforward replacement of infrastructure that had been standing in essentially the same configuration for decades. Creekside Commons had decided that this fence was unapproved construction, that it violated Section 8(1)(c) of their architectural guidelines, and that I was required to submit plans for review by their Architectural Review Committee before any fence construction could be considered compliant. I sat at my desk for a long moment with both letters in my hands, one in each, and I thought about the nature of certain kinds of people. The kind who receive a legal document explaining exactly why they're wrong and respond by finding something new to be wrong about, the kind who have just enough authority to cause problems and just enough ignorance to not understand what those problems are going to cost them. And then I put both letters in the folder, picked up my phone, and called Gary again. They sent another one, I said when he answered. And there's a new violation. The fence. Gary didn't say anything for a moment, and then he said very evenly, "Tell me about the fence." So I told him. I told him about the replacement, the location, the timeline, the fact that we were putting back what had been there before within the same footprint and along the same boundary. I told him they were citing their architectural review process, demanding that I submit plans retroactively for a fence that was already standing. On your property, Gary said. On my property. The fence is on your property. Every post, every board, every inch of it. Right, Gary said, and this time I could hear something shift in his voice, a kind of settling, like a chess player who has just watched his opponent make the move he was waiting for. Then here's what I need you to do. I need you to take photographs of that fence today, all of it, every section, from multiple angles with timestamps, and I need you to pull whatever records you have showing the location of the original fence, survey documents, old photographs, anything that establishes that this replacement is in the same location as what was there before. And then I need you to send me everything, because we're going to draft a second cease and desist for the fence violation, and we are also going to start preparing for the very real possibility that these people are going to file for a judgment and try to put a lien on your property, which is when this stops being an annoyance and starts being something we handle in court. And when that happens, I asked. When that happens, Gary said, we counter. We've got harassment, we've got continued action after formal legal notice, and depending on what their own records show about what they knew and when they knew it, we may have quite a bit more than that. Just keep the folder current. Every letter, every date, every dollar amount they're claiming. That folder is going to be worth money to us. I took the photographs that afternoon. I pulled the survey documents. I sent Gary everything he asked for. And 2 weeks later, almost to the day, the letter arrived that I had known was coming since the moment I opened that first envelope. The one informing me that Creekside Commons HOA had filed for a judgment against my property and was seeking to impose a lien in the amount of $4,200, representing accrued fines for both violations plus administrative fees. I put it in the folder. I called Gary. And for the first time since this whole thing started, I felt something that wasn't frustration or exhaustion or low-grade contempt. It felt, if I'm being honest, a little bit like anticipation. Gary filed the counterclaim on a Tuesday morning, and by Tuesday afternoon I had already received a phone call from a woman named Diane, who identified herself as the property manager for Creekside Commons, which meant she was the paid professional the board hired to handle the day-to-day administration of the association, which also meant she was the person whose job it had been to catch this kind of problem before it metastasized into active litigation. Which meant this phone call was equal parts damage control and reconnaissance, and I had been around long enough to know that the right way to handle it was carefully. I'm reaching out because we received some paperwork from your attorney this morning, Diane said, her voice carrying that particular brand of studied calm that property managers develop after years of mediating disputes between people who own adjacent property and have fundamentally incompatible ideas about where one person's rights end and another's begin, and before things go any further down that road. I just wanted to have a direct conversation and see whether there might be a way to resolve this that works for everyone involved, because I think if we can just sit down and talk through what's actually happening here, we might find that there's more common ground than it seems like right now. I was sitting at my desk with a copy of the counterclaim in front of me, and I took a moment before I responded because I wanted to be deliberate about what I said and how I said it. Diane, I appreciate you calling, and I want to be straightforward with you about something before we go any further, because I think it'll save us both some time. My attorney has been very clear with me that I should not be discussing the substance of the legal matter directly with any representative of Creekside Commons, and I intend to follow that advice, so there's a ceiling on what this conversation can accomplish. But I will tell you this much, and I'd ask you to take it back to whoever on that board is making the decisions here, because I think they need to hear it plainly. This did not have to get to where it is. We sent 2 cease and desist letters. Both of them went out certified mail, both of them were delivered, both of them were signed for by someone at that management office, and both of them were ignored. Not responded to, not disputed, not returned, ignored. The board had every opportunity at multiple points in this process to pull their own historical files, look at the 1999 litigation, recognize that they were operating well outside their jurisdiction, and stop what they were doing. They chose not to take any of those opportunities, and so here we are. Diane was quiet for a moment in the way people are quiet when they've received more directness than they were expecting and need a beat to recalibrate. I understand your frustration completely, she said, pivoting to the conflict resolution language that is apparently standard issue for property managers, and I want you to know that the board genuinely takes your concerns seriously, and that their intention has always been simply to maintain the community standards that all residents depend on for the value and enjoyment of their. Diane, I said, and I kept my voice even because I wasn't angry at Diane specifically. Diane was doing her job. I am not a resident. That is not a technicality or a point of dispute. It is the foundational legal fact of this entire situation. My property is not part of Creekside Commons. It has never been part of Creekside Commons. A court determined that 25 years ago and entered a judgment that is still on the record, and if anyone on that board had spent 30 minutes with their own files before any of this started, they would have known that before they sent the first notice. What I would genuinely encourage you to do, and I mean this sincerely and not as a threat, is to make sure that whoever the board is working with on the legal side has had a full and honest conversation with the board about where this is headed, because I think there may be a gap between what the board believes about their position and what their attorney actually thinks about it, and that gap is going to become very apparent when we get in front of a judge. She thanked me for my time in the tone of someone who had not gotten what they came for but was too professional to say so, and we ended the call. I dialed Gary before I'd even set the phone down. "Their property manager just called me," I said when he picked up. "Woman named Diane. She wanted to talk through whether there was a way to resolve this that works for everyone involved." "I figured they'd make some kind of outreach once the counterclaim landed," Gary said. "What did you tell her?" "I told her I couldn't discuss the substance of the legal matter. I told her the board had every opportunity to stop before this became what it is. I told her to make sure whoever their lawyer is has been straight with them about where this is headed, and then we ended the call. I didn't give her anything specific, and I didn't make any representations about what I would or wouldn't accept." "That's exactly right," Gary said. "That is exactly how that conversation should have gone. Do not talk to the property manager again about any of this, and if any board members call you directly, which they may, the answer is the same. You're happy to talk about anything other than the legal matter, and anything related to the legal matter goes through me. The reason for that isn't just legal caution, it's practical. Every informal conversation you have with someone on their side is an opportunity for something to get remembered slightly differently than it happened, or characterized slightly differently in a document later, and we have a clean record right now, and I want to keep it clean." Their lawyer turned out to be a man named Patterson, and he called Gary 3 days after the Diane conversation. Gary briefed me that evening, walking through it the way he always does, methodically, in sequence, without inflection, though I've known him long enough to read what he actually thinks in the architecture of what he chooses to emphasize and what he passes over quickly. "Patterson called to open settlement discussions," Gary said. He was pleasant enough, reasonably professional, clearly had been briefed on the history of the property and the 1999 litigation, which tells me he's done more homework than the board did before any of this started. His opening position was that his clients would be willing to consider dropping the fines, all of them, both violations, the full amount they've been claiming in exchange for a mutual release of claims, and separately, a voluntary agreement on your part to submit future construction projects on your property to their architectural review process. I listened to that and let it settle before I said anything. "He wants me to submit to their review process voluntarily," I said. "The process that exists to govern their members. Which I am not. He wants me to agree to behave as though I'm a member of an HOA that has no jurisdiction over my property, in exchange for them dropping fines they had no legal authority to assess in the first place. That is what he's offering." "That is the substance of the offer, yes," Gary said. "And what did you say to him?" "I told him that the offer was not acceptable in any of its components," Gary said, and I laid out exactly why. "I told him that my client has no obligation to submit to any process maintained by Creekside Commons, voluntary or otherwise, under any circumstances, because voluntary submission to an unauthorized process has a way of becoming evidence of tacit acceptance of that process, and we're not going to create that kind of ambiguity. I told him that the fines were assessed without legal authority, and my client has no intention of paying any portion of them regardless of the amount, because paying any portion of an unlawful fine is an acknowledgement that the fine had some legitimacy, and it didn't. And I told him that if his clients are genuinely interested in resolving this matter, what that looks like from our side is a full withdrawal of all fines and all related filings, a written and signed acknowledgement from the board that your property is not subject to HOA jurisdiction, a commitment that they will not pursue any future action against your property, and reimbursement of your legal fees. Because you should not have had to spend money on attorneys to defend yourself against an HOA that had no authority over you and had that fact explained to them in writing on 2 separate occasions." "How did he respond to the fees?" I asked. "He said that was going to be a significant obstacle," Gary said. Which is lawyer language for his clients are going to hate that part. But he said he'd take the full counter back to them and get back to me, and I told him to take his time and think carefully, because the longer this goes, the more our legal fees grow, and the more our legal fees grow, the larger the number we're going to be putting in front of a judge when we ask for reimbursement. Patterson called back 4 days later, and the new offer was cleaner than the first one. They'd drop every fine, both violations, no conditions attached about the review process, and both sides would sign a mutual release and walk away. Gary presented it to me and gave me time to think about it, which I appreciated, because he never pushes me toward a conclusion, he just makes sure I have what I need to reach one. Walk me through what a mutual release actually means in practical terms, I said, because I want to make sure I understand exactly what I'd be giving up. A mutual release means both parties agree to release all claims against each other arising from this dispute, Gary said. So they drop the fines and the judgment filing, you drop the counterclaim, and neither side can pursue the other for anything related to what's happened so far. The slate is clean. And the record, I said. What happens to the record? The court filings remain public record, Gary said. You can't expunge them. But there'd be no judgment entered against either party. It would simply be a voluntary dismissal of all claims. So the next board 7 or 8 years from now goes through the files and finds that the HOA filed for a judgment and a lien against my property, and the whole thing just quietly disappeared, and they think, well, that's interesting, maybe that's worth trying again, I said. Because there's nothing in the record that says they were wrong. There's no finding. There's no acknowledgement. There's just a filing and a dismissal and a big blank space where the outcome should be. That is a legitimate concern, Gary said, and his tone told me that he shared it. Then no, I said. Tell Patterson no. Tell him that what we want has not changed, written acknowledgement from the board signed, that my property is outside their jurisdiction, and that all notices and fines were issued in error, and a commitment that they will not take any future action. And fees. We want fees. Because I need something in writing that the next board president can't look at and wonder about. I need something that says in plain language that they were wrong, so that whoever comes after Gerald Hooper doesn't look at this and think there's unfinished business. Fees are going to be the sticking point, Gary said. Patterson's clients are not going to want to pay your legal fees. That's going to feel like a significant concession to them, possibly more than the acknowledgement, because the acknowledgement is words on paper and the fees are real money. I understand that, I said. I'm not moving off it. All right, Gary said. I'll call Patterson in the morning. What happened next was not something I had anticipated, though Gary told me afterward that in his experience it was not entirely surprising. When a negotiation stalls and the party with the weaker position feels the walls closing in, they have two choices. They can reassess their position and make a realistic offer, or they can convince themselves that the best defense is a sudden and aggressive offense. Gerald Hooper, board president of Creekside Commons, chose the offense. I came home on a Thursday to find a new letter on my desk, not from Patterson, not from Diane, but on board letterhead, signed by Hooper himself, informing me that during a recent review of community records, the board had identified 2 additional violations on my property. The first was a storage shed near the tree line that allegedly exceeded the height restrictions set out in Section 9(4)(a) of their guidelines. The second was what they were characterizing as improper drainage modifications that they claimed were directing water runoff toward common areas in violation of Section 11(2)(b). Fines for both new violations would begin accruing immediately. The shed had been standing in the same location for 19 years. I had the county building permit. The drainage swale had been put in by my father before I inherited the property, before Creekside Commons existed as a legal entity, graded specifically to carry water away from the boundary and toward my own retention area, the precise opposite of what they were claiming. I stood at my kitchen counter and read that letter twice, and what I felt was not the frustration or exhaustion that had characterized most of my emotional responses to this situation up to that point. What I felt, if I'm honest about it, was a kind of cold and clarifying calm, because when someone in the middle of active litigation, with a counterclaim on the table, with a documented history of jurisdictional overreach already established in the record, responds to a rejected settlement offer by inventing violations against a 19-year-old shed and a drainage feature that predates their own founding, that is not a legal strategy. That is what panic looks like when it puts on a suit. I photographed everything that afternoon, the shed from every angle, the swale from both ends, the surrounding grade, the tree line, the boundary markers. I pulled the county permit records for the shed. I found the original grading plan in the property files, a hand-drawn survey document my father had commissioned that showed the drainage design with a date stamp that put it 4 years before Creekside Commons held its first board meeting. I organized everything into a new folder and called Gary. "They sent 2 more violations," I said when he answered. "The shed by the tree line and the drainage swale on the east side. They're claiming the shed exceeds height limits and the swale is directing runoff toward their common areas." Gary was quiet for a moment that felt longer than it probably was. "How old is the shed?" he asked. 19 years. I have the county building permit with the date of inspection and approval, and the permit lists the dimensions including the height, so we can show the height hasn't changed since the day it was built. "And the drainage?" My father had the swale put in before I owned the property. I have the original grading plan dated 4 years before the HOA was founded. The plan shows the drainage running toward my retention area, not toward their common space. They've got the direction of flow exactly backwards. "And they sent this," Gary said slowly, "while Patterson and I are in the middle of settlement discussions. While the counterclaim is active. While there is an open legal proceeding between the 2 parties. Signed by Hooper himself," I said. "Board president letterhead, his signature at the bottom." Gary took a breath that I could hear through the phone. "I want to explain to you carefully what this does for us," he said, "because I think it changes the shape of this case in a meaningful way. Up until now, our harassment claim has been based on a pattern of issuing notices and assessing fines against property outside their jurisdiction after being formally notified in writing that they were operating outside their jurisdiction. That's a solid harassment claim on its own, and I felt good about it going into a hearing. But what Hooper has just done is add a layer to that pattern that a judge is going to find very difficult to ignore. He has manufactured 2 new violations against a 19-year-old structure with a county permit and a drainage feature that predates his organization's existence in the middle of active litigation, after settlement discussions broke down, within days of Patterson relaying our position to him. A judge is going to look at that timeline, and they are not going to see a community association trying conscientiously to enforce its standards. They are going to see a board president using the violation process as a weapon in a legal dispute, and that is a significantly more serious finding than simple overreach. "What do we do with it?" I asked. "We file an amended counterclaim," Gary said, "and we add the new violations to the harassment count, and we add a separate count for retaliatory conduct. And then I'm going to call Patterson, not to negotiate, but to make sure he is aware that his client sent new violations while we were in settlement discussions, because I want his reaction on record, and because I think there's a reasonable chance he didn't know it was coming. Hooper doesn't strike me as someone who keeps his lawyer fully informed before he acts." Patterson's reaction, as Gary described it to me afterward, was a silence that lasted long enough to be its own kind of answer. "He said he'd have to speak with his clients," Gary told me, and his voice had the quality of a man who has just been told that the people he is representing have done something that makes his job considerably harder, which is a tone I've heard before, and it generally means the lawyer is not happy, but is too professional to say so directly. I told him that we would be filing an amended counterclaim to reflect the new violations and the retaliatory conduct, and that I wanted him to understand that from our perspective, the window for a reasonable settlement was narrowing, not because we were unwilling to resolve this, but because every additional action his clients took was another item on the list that we'd be presenting to a judge. The discovery requests went out the following week, board meeting minutes going back 5 years, all correspondence related to my property, all records of fine assessments in which properties had been cited and for what, all communications between board members about the violations, and all records related to the original 1999 boundary litigation that should have been in their files, and should have told every board since then exactly where the line was. Gary also included a specific request for communications conducted through personal email addresses or text messages, because in 15 years of working together, I had learned that the official record of what an HOA board does and the actual record of what an HOA board does are frequently 2 very different documents. They took the full allowable period to respond, and then sent over boxes of material that Gary described as a document dump designed to obscure rather than illuminate. Thousands of pages of meeting minutes, maintenance records, vendor contracts, and correspondence that had nothing to do with my property, buried in which were the documents we actually wanted. Gary went through all of it over 4 days, and when he called me to report what he'd found, his voice had a quality I had come to associate with moments when the case tilted decisively. "Their board minutes are very interesting," he said. "There's a meeting from about 8 months before they sent you the first notice. This is the new board's first full review of what they're calling legacy issues, and your property comes up. And what the minutes reflect is that one board member raised the fact that there was historical litigation involving the property, and rather than treating that as a reason to investigate before taking any action, Hooper made a motion to issue notices on the grounds that the historical litigation, and I'm reading directly from the minutes here, may not reflect current conditions and boundaries. That motion passed 3-2. I sat with that for a moment. "They knew there was litigation," I said. "They knew before they sent the first notice that there was a legal history involving my property, and instead of pulling the judgment and reading it, Hooper decided that the litigation might not reflect current conditions and voted to proceed anyway." "They knew there was a reason to be careful," Gary said, "and they explicitly decided not to be careful. That is the distinction that matters, because it eliminates the good faith ignorance defense. They can't stand in front of a judge and say we had no idea there was a history here. We made an innocent mistake, because their own minutes show that they knew there was a history, they debated it, and they chose to proceed without investigating it. That's not a mistake. That's a decision, and they're going to have to own it." The personal emails arrived 3 weeks later, after Gary sent a second and considerably more pointed letter making clear that communications conducted through personal accounts used for a business fell squarely within the scope of the original request, and that failure to produce them would be raised with the court. The supplemental production contained email chains that had clearly not been reviewed before they were sent over, because no one who had reviewed them would have sent them over willingly. Hooper had been running a significant portion of his board activity through a personal Gmail account. There was a chain from the period just before the first notice in which he described my property as a long-standing thorn that previous boards had been too afraid to deal with, and said that he intended to be different. There was a chain from after our first cease and desist arrived in which he told the 2 board members copied on the email that he wasn't about to let some lawyer's letter push them around, and that the fines should keep running. And there was a chain from after the counterclaim was filed, the one that Gary flagged specifically, that he read to me word for word over the phone, in which one of the other board members expressed serious concern that they had gotten in over their heads and asked whether they should reconsider their position, and Hooper wrote back that they had come too far to back down now, and that this was exactly what the association's insurance was there for. "He thinks the insurance covers it," I said when Gary finished reading. "That's what the email suggests," Gary said. "And that almost certainly explains why he didn't settle when he had the chance, and why he keeps escalating instead of retreating, because from where he's sitting, the association's insurance company absorbs whatever judgment comes down and the board moves on. Which may or may not be accurate depending on the specific terms of their policy. Insurance coverage for HOA boards is complicated and often has exclusions for bad faith conduct. But here's the more important point: even if the insurance covers the judgment, it does not cover the board members personally if we can establish that they acted in bad faith." And an email from the board president saying he's not going to let a lawyer's letter push them around, written after he had received formal legal notice of his jurisdictional overreach, is exactly the kind of document that makes a bad faith finding considerably easier to support. I asked Gary plainly where he thought this was going, not what the legal arguments were or what the strategy was, but what he actually thought was going to happen when we got in front of a judge and this whole sequence of events was laid out from beginning to end. He was quiet for a moment before he answered, the kind of quiet that with Gary means he's about to tell me something he is genuinely confident in. "I think we're going to win," he said. "I think we're going to win on the core jurisdictional question because the law is unambiguous and the 1999 judgment is unambiguous, and nothing Hooper has done changes either of those things. I think we're going to win on the harassment claim because the documentation of what they did after receiving our cease and desist letters is clean and damning. I think the retaliatory conduct claim is strong enough that a judge is going to take it seriously. And I think we have a real argument for fees, which is what I want to focus on between now and the hearing, because the email in which Hooper says he's not going to let a lawyer's letter push them around, sent after he had formal written notice that he was wrong, is the kind of evidence that makes fee awards happen. The question isn't really whether we win. The question is how much we win by. Then let's go win, I said. The hearing was set for a Tuesday, which gave Gary and me the better part of 3 weeks to prepare after the court confirmed the date, and Gary used every day of it. We met twice in his office, once to go through the full sequence of events from the beginning so that Gary could stress test the narrative for any gaps or vulnerabilities, and once to go through the documents that were going to be entered into evidence, which by that point filled 2 accordion folders and a banker's box that Gary kept on the corner of his desk like a trophy. He walked me through what to expect, how the HOA's attorney would likely approach it, where he anticipated Patterson would try to find daylight, and what our responses to each of those attempts would be. He was thorough and methodical and calm in the way that good lawyers are calm before a hearing they expect to win, not relaxed, not casual, but settled, the way a person is settled when they know exactly where they're standing and exactly what they're about to do. What Gary did not tell me, because he didn't know, was that 3 days before the hearing Patterson was going to withdraw from the case. I found out from Gary, who called me on a Saturday morning with a quality in his voice that I had never heard before in 15 years, something between professional composure and barely contained disbelief. "I need to tell you something that has just happened," he said, "and I want you to hear it and not read anything into it that isn't there, because my instinct is that this is good for us, but I want to think it through carefully before I say that definitively." Patterson filed a motion to withdraw as counsel for Creekside Commons yesterday afternoon. The court received it late Friday. He cited irreconcilable differences with his client on matters of case strategy, which is the language lawyers use when their client has stopped listening to them and they don't want to be standing at the table when the roof comes down. I sat down slowly in the chair by the window. "He quit," I said. "He withdrew," Gary said, which is the professional term, but yes, 3 days before the hearing, Patterson decided he would rather file a motion and take the reputational hit of a last-minute withdrawal than stand in front of a judge and argue this case. That tells you something very specific about what Patterson thinks of their position, because withdrawing from a case 3 days before a hearing is not something any attorney does lightly. That is a decision that costs you something professionally, it damages your relationship with the client, it creates complications for the court, and you only make that choice when the alternative, actually trying the case, looks worse. "So what happens now?" I asked. "Do they get a continuance?" "That's what they're going to ask for," Gary said, "and I'm going to oppose it, and here's why. They have had months to prepare for this hearing. Patterson has been their counsel throughout the entire proceeding, and whatever documents and strategy he developed belong to the client, not the attorney. A new lawyer can walk in with Patterson's files and be ready to proceed. More importantly, a continuance rewards the board for the conduct that drove Patterson away in the first place, which was almost certainly Hooper refusing to follow legal advice and insisting on an approach that Patterson wasn't willing to put his name on. I am going to argue that the withdrawal is a consequence of the board's own decisions, that granting a continuance would prejudice my client who has been waiting for resolution of a matter that should never have reached this point, and that the court should proceed as scheduled. The judge, her name was Carver, and Gary had appeared before her several times over the years and described her as sharp, impatient with nonsense, and disinclined to let procedural maneuvering substitute for preparation, denied the continuance request on Monday morning. She acknowledged the withdrawal, noted that it had occurred at an extremely late stage of the proceedings, and ruled that the timing and circumstances of the withdrawal did not constitute grounds to delay a hearing that had been properly scheduled and for which both parties had had adequate time to prepare. Creekside Commons would need to appear Tuesday either with new counsel or represented by a board member, and the hearing would proceed. Hooper showed up with a new lawyer. I don't know where he found her in 72 hours, but her name was Carla Briggs, and she walked into that courtroom on Tuesday morning carrying a trial bag that looked like it had been packed in a hurry, which it had been, and wearing the expression of someone who has been handed a case file at the last minute and has spent the intervening time discovering things about it that she wished she hadn't. She was not Patterson. Patterson, whatever his failings as a strategist for this particular client, was experienced and prepared and knew the file. Briggs knew the file the way you know a city when you've studied the map but never walked the streets. The basic geography was there, but the texture was missing, and in a hearing like this one, texture is everything. Gary and I sat at our table, and Gary leaned over and said quietly, without looking at me, "New lawyer." He found a new lawyer. "I can see that," I said. "She doesn't know this file," Gary said. "She knows what she could read in 72 hours, which is not the same thing." Judge Carver came in at 9 o'clock exactly, settled into her chair, looked at both tables with the evaluating gaze of someone who has spent years reading rooms professionally, and said, "We're here on the matter of Creekside Commons HOA versus the property at," and read my address into the record, along with the counterclaim filed by the property owner. Before we begin, I want to note for the record that this court denied a motion for continuance filed by the plaintiff on Monday, and we will be proceeding today as scheduled. Ms. Briggs, I understand you've recently come onto this matter, and I want to give you the opportunity to tell me whether you're prepared to proceed. Briggs stood up and said that she was prepared to proceed, which was the only thing she could say, and Judge Carver nodded in a way that suggested she would be watching carefully to see whether that was true. It was not entirely true. But we didn't find that out until Briggs stood up to make her opening, and I watched Gary watch her the way a chess player watches an opponent's hand move toward a piece, still, attentive, already thinking about what comes next. Briggs opened by laying out the HOA's position in broad strokes, the violations, the fines, the judgment filing, the argument that my property was subject to their jurisdiction, and that the notices had been properly issued under their governing documents. She was organized and she spoke clearly, and if you didn't know the case, it probably sounded reasonable. But she made a mistake in the first 4 minutes that Gary had clearly anticipated, because I watched him write something on the legal pad in front of him and underline it twice. She argued that the 1999 litigation was not controlling precedent because, and this was the argument, the actual argument that she had apparently decided was their best path forward, because the boundary determination made in that case had been based on survey data that had since been superseded by updated county assessor records, and that the current assessor records showed a boundary line that placed a portion of my property within the HOA's jurisdiction. Gary set his pen down on the pad very carefully, and I could feel him not smiling. When it was his turn, he stood up and he said, "Your Honor, the plaintiff has just argued that the 1999 judgment is not controlling because the boundary survey it relied upon has been superseded by updated county assessor records. I'd like to address that argument directly before we go any further, because I think it's going to save us all a significant amount of time." He picked up a document from the stack in front of him and handed a copy to the clerk for the judge and walked another copy to Briggs's table, and then he said, "What I've just handed the court is a certified copy of the county assessor's current parcel record for my client's property, pulled from the county's own database last Thursday. I'd ask the court to note the boundary coordinates listed on that record, and I'd ask Ms. Briggs to compare those coordinates to the boundary coordinates established in the 1999 judgment, which is Exhibit A in the plaintiff's own filing." He paused for exactly the right length of time. "They are identical, Your Honor. The current assessor records and the 1999 judgment describe the same boundary. The argument the plaintiff has just made to this court is contradicted by the plaintiff's own exhibit." Judge Carver looked at the document. She looked at Exhibit A. She looked at Briggs. "Ms. Briggs," she said in a tone that had gone very quiet and very precise, "do you want to respond to that?" Briggs looked at the two documents side by side, and I watched her face do something complicated. "Your Honor," she said, I'd ask for a brief recess to review the materials." "We've been in session for 11 minutes, Judge Carver said. "We'll continue. You'll have the opportunity to address it on redirect." It went on like that. Not always that dramatically, not every exchange landing with the same clean force as that first one, but consistently, methodically, Gary working through the record the way someone works through a proof, step by step, each piece building on the last, each document placed in front of the judge at exactly the moment it did the most damage. The certified mail return receipts showing the dates they'd received our cease and desist letters. The board minutes showing that Hooper had moved to proceed despite knowing there was historical litigation. The timeline showing fines continuing to accrue after the certified letters were delivered. The county building permit for the shed, date-stamped, dimensions included, showing the structure had existed for 19 years and had been approved at the height they were now claiming was a violation. The grading plan for the swale, hand-drawn on my father's letterhead, dated 4 years before the HOA's founding documents were filed with the state. And then Gary introduced the emails. He had saved them, I realized, for this moment specifically, not because they were his strongest evidence on the jurisdictional question, which they weren't, but because they changed the character of the entire proceeding, because they transformed it from a dispute about a boundary line into something the judge could not look at neutrally. And Gary wanted the judge to have spent the first hour and a half seeing all the documentary evidence before she saw what the man who had generated all of it had been saying privately to his colleagues. "Your Honor," Gary said, "I'd like to turn the court's attention to Exhibit 14, which is an email produced by the plaintiff during discovery, sent from the personal Gmail account of Gerald Hooper, who serves as president of the Creekside Commons Board, to 2 fellow board members, dated approximately 3 days after this office delivered the first cease and desist letter to the plaintiff by certified mail." He read the email into the record, Hooper's words about not letting a lawyer's letter push them around, about the fines continuing, about having come too far to back down, about the insurance being there for exactly this kind of situation. He read each one slowly and without commentary, because the emails didn't need commentary. They were their own commentary. When he finished, he set the exhibit down and said simply, "Your Honor, I have nothing further to add to those documents. I think they speak for themselves." Judge Carver had been writing steadily while Gary read, and she did not look up immediately when he finished. The courtroom was quiet in the way courtrooms get quiet when something has just happened that everyone in the room understood. Hooper was sitting at the plaintiff's table next to Briggs, and I did not look at him directly, but I could see him in my peripheral vision, and what I saw was a man sitting very still with his jaw tight, looking at the table in front of him. Briggs did her best. I'll give her that. She was working with a bad hand that she'd been dealt at the last minute by a client who had apparently not been fully candid with her about what was in the record, and she stood up and made the arguments she had available to her, that the HOA had acted in good faith on a reasonable interpretation of their jurisdiction, that the 1999 judgment had been misapplied, that the shed and the drainage violations were legitimate concerns regardless of the property's jurisdictional status. She was professional and she was composed, and almost none of it landed, because Gary had already put the documents in front of the judge, and the documents said what they said. Then something happened that nobody in that room was expecting. Judge Carver looked up from her notes during Briggs's closing argument and said, "Ms. Briggs, I want to ask you a direct question, and I'd like a direct answer. Are you aware of any other properties adjacent to or near Creekside Commons that have received violation notices from this board during the current board's tenure?" Briggs stopped. It was the kind of stop that happens when a question arrives from a direction you weren't watching. "Your Honor," she said carefully, "I'm not certain I understand the relevance of." "The relevance," Judge Carver said, still in that quiet, precise tone, "is that I am looking at a discovery production that includes fine assessment records for the past 5 years, and I am noticing that the volume of notices issued against properties on the eastern boundary of the development, which is the boundary adjacent to my defendant's property, is substantially higher than the volume issued against properties on any other boundary. I'm also noticing that several of those notices appear to have been issued against properties that have subsequently produced documentation showing they are not subject to HOA jurisdiction. I want to know whether the plaintiff is aware of other properties in a similar situation to my defendant's." The silence that followed that question was the longest silence of the entire hearing. Briggs turned to Hooper, and there was a brief, whispered exchange that I could not hear, but which Gary later told me, based on Hooper's body language, did not appear to be a productive conversation. Briggs turned back to the judge and said that she was not in a position to speak to other properties, and that the matter before the court concerned only my property. "It does today," Judge Carver said. "That may not continue to be the case." She called a 20-minute recess, and Gary and I went into the hallway and found a quiet corner, and Gary said, very quietly, "She found the pattern herself." I didn't put that in front of her, she found it in their own discovery production. "What does that mean for us?" I asked. "For us today, it probably doesn't change the outcome, because I already think the outcome is good." Gary said. But what it means more broadly is that the judge is looking at this and seeing something larger than one property dispute. She's seeing a board that has been systematically issuing notices against non-member properties along a specific boundary, which is a pattern of conduct that goes well beyond what we've alleged in the counterclaim. I don't know what she's going to do with that observation, but I know she's not going to forget it. We went back in. Briggs finished her argument. Gary gave a closing that was about 10 minutes long and used no notes, just walked the judge through the timeline one final time. The history, the litigation, the notices, the certified letters, the continued fines, the new violations, the emails, and ended by saying that his client had spent money on legal fees to defend himself against an organization that had no authority over him, had been told that it had no authority over him, and had proceeded anyway. And that the law provided for fee shifting in exactly these circumstances, and he was asking the court to apply it. Judge Carver did not take it under advisement. She did not say she'd issue a written ruling. She looked at her notes for approximately 90 seconds while the room waited, and then she looked up and she ruled from the bench. She found in my favor on every count. The jurisdictional question, my property was not subject to HO jurisdiction. The 1999 judgment was controlling. Nothing in the current assessor records altered that conclusion. The fine assessment, all fines were assessed without legal authority and were void. The harassment claim, the board had received formal legal notice of the jurisdictional issue and had continued to assess fines and generate new violations, and that conduct met the standard for harassment. The retaliatory conduct claim, the new violations issued against the shed and the drainage swale, timed as they were in relation to the settlement discussions and the filing of the amended counterclaim, constituted retaliatory conduct. And fees, the court awarded my legal fees in full, finding that the board's conduct after receiving the cease and desist letters, including the statements in the emails which demonstrated a deliberate decision to continue despite legal notice, supported fee shifting under the applicable statute. Beyond the fees, the court awarded damages on the harassment claim in the amount of $8,000, finding that the board's sustained and deliberate campaign of notices, fines, and retaliatory violations against a property they had been formally informed was outside their jurisdiction constituted actionable harassment under the statute. On the business disruption claim, the court awarded an additional $11,000, finding that the ongoing lien threat and judgment filing had created a documentable interference with my ability to conduct normal business operations on the property during the period in question, financing conversations that had to be disclosed, contractors who had asked questions, a refinancing that had been delayed while the lien threat was active. The total award inclusive of fees came to just over $31,000, which did not fully account for the time I had spent on this, the aggravation, the weekends going through documents, the mental overhead of carrying a legal fight for the better part of a year. But it was enough. It was more than enough to make the point that needed to be made, which was the same point I had made 25 years ago and apparently needed to make again. That this particular piece of ground was mine, that it had always been mine, and that the cost of forgetting that was going to be considerably higher than anyone on that board had budgeted for. And then she said one more thing. She said it in the measured, careful language that judges use when they are making a statement for the record that they intend to be heard beyond the immediate parties, and she said that the court had observed in the plaintiff's own discovery production what appeared to be a pattern of violation notices issued against properties along the eastern boundary of the development, some of which may not be subject to the HOA's jurisdiction, and that the court was referring the matter to the state's HOA regulatory office for a broader review. She was not making a finding on that question today, she said, because it was not before her today. But she was not going to look at what she had seen and pretend she hadn't seen it. Briggs was writing rapidly. Hooper was not writing anything. He was sitting very still, the way people sit when they are absorbing something they are not yet fully able to process, and I looked at him directly for the first time that morning, and what I saw on his face was not anger and it was not defiance. It was the particular expression of a man who had been absolutely certain he was holding a winning hand and has just watched every card turn over wrong. Outside on the courthouse steps afterward, Gary and I stood in the thin autumn sunlight and he shook my hand and said that it had gone about as well as it possibly could have gone, and I said I knew, and we stood there for a moment in the way you stand somewhere when something is finished. The regulatory referral is the thing that's going to keep them up at night, Gary said. Because that's not something that goes away when the hearing ends. That's a process that starts. How many properties do you think are in the same situation as mine? I asked. Based on what I saw in their assessment records, Gary said. At least 4. Possibly 6. And those people are going to find out about this ruling, and some of them are going to call lawyers, and the Creekside Commons Board is going to spend the next 2 years dealing with the consequences of what Gerald Hooper decided to do when he found my client's property in the legacy files and thought he'd found something that previous boards had been too timid to address. 2 board members resigned before the end of the week. I know this because it was in the minutes of an emergency board meeting that someone posted in the neighborhood's online forum, which I am not a member of, but which a neighbor who found the whole situation entertaining had been forwarding me updates from since the hearing was first scheduled. The minutes reflected that the resignations were effective immediately, and that the remaining board members had voted to retain new legal counsel to review all outstanding notices issued during the current board's tenure. There was no mention of Hooper by name in the public minutes, but the person who posted them added a note that the meeting had been, in their words, extraordinarily uncomfortable to sit through. Hooper himself resigned 10 days later. I found out from the same neighbor, who sent me a screenshot of the announcement posted in the forum, along with a message that said simply, "Thought you'd want to see this." The HOA sent a community-wide letter the following week, drafted by their new council, acknowledging the court's ruling, confirming that my property was not and had never been subject to HOA jurisdiction, and advising residents that the board was conducting a comprehensive review of all violation notices issued since the beginning of the current board's tenure. The letter did not mention Hooper by name. It did not use the word harassment or the word retaliation. It was written in the careful, bloodless language of legal damage control, every sentence shaped to acknowledge without admitting, to inform without explaining, to apologize for nothing while making clear that something had gone very wrong. I read it once, set it down, and went to my desk. I have a frame on the wall of my home office, a simple black frame, nothing fancy, and inside it I keep documents from the significant moments of my professional life. Contracts that changed things. Correspondence that mattered. The original 1999 judgment from the first time we went through this, which I framed after that hearing, and which has been on that wall ever since, a reminder that some fights are worth having all the way to the end. I printed the new judgment. I printed Judge Carver's ruling in full, every finding, every count, the fee award, the regulatory referral, all of it. I printed Hooper's email, the one where he said he wasn't going to let a lawyer's letter push him around, and I paperclipped it to the back of the ruling as a kind of footnote. And I put all of it in the frame next to the 1999 judgment, where there had always been empty space, as if the wall had been waiting for it. I still have the lawyer on retainer. I'll keep him, because somewhere out there in some development I haven't heard of yet, there is a new board being formed, and somewhere in the files of that new board is a property that someone flagged 15 years ago and nothing was ever done about it, and eventually someone is going to open that file and think, previous boards were too timid to deal with this. Let them think it. I'll be here.
I would like to thank you for watching the video to the end. To encourage us to make more videos, please like, subscribe, comment, as well as share.